parties. So as you can imagine, a consent award reads very differently from a final award in many sense.
Yeah, as an arbitrator, I'm obviously also very pleased when parties manage to settle the issues by the dispute by themselves. But as the DELOS rules does contemplate, it is possible for there to be a consent award, and of course the key advantage to that is that you can then utilize the New York Convention for any enforcement thereafter. Going back, I think, a bit to the default award, just to cater for parties who, for whatever reason, do not wish to participate, and I think it would be 12.4, that provides that the tribunal may proceed with the arbitration nonetheless, even if the parties do not participate in the proceedings.
And writing a default award or an award where a party does not participate, we were discussing with some of the panelists earlier, is often tougher to write than to write an award where parties have in fact participated, because you have to be so cautious that you're not just letting one party that's representing itself have a free ride in many senses. So.
Yeah, so a default award is very different from default judgment. Termination award, this is when, for whatever reason, the tribunal finds that it can't come to the end of the proceedings and dispose of the issues in a final award. The termination award seeks to terminate the arbitration. Again, this is clearly contemplated within the DELOS rules, and it's also in other institutional rules, which reserves the power for the tribunal and the institution to call an end to the proceedings, primarily and usually because when the parties fail to pay the cost of arbitration.
Not sufficiently determined, parties needed additional interpretation, so very often that finds itself, or something that got missed out can be found in an additional award.
Now we move on to the next slide, the structure and outline. Again, this is not meant to be overly prescriptive, perhaps more as a guide or reference or comfort, if you like. Perhaps a bit simplistic, the title page, which I think a lot of us tend to skip over, but nonetheless is extremely important. This sets the baseline and helps facilitate the enforcement of the award thereafter if necessary. So the parties clearly stated, and it's helpful to name them as the claimant and the respondent, so thereafter they can be referred to in shorthand. The applicable procedural law. In this case, I've used the example of the International Arbitration Act of Singapore and the legal and procedural rules. So here we've assumed or taken an example of the DELOS rules of arbitration. All these, again, it's on the arbitrators to check that they are entirely accurate. The information, other information that would be included would be the award, type award. So you can see here on the screen, we refer to a final award. But for example, if it's a partial award or an interim award, number 1, 2, 3, 4, 5, and so on, that states so. The date and the details of the tribunal as well as the seat of arbitration. You want to touch on the parties?
The parties, of course, it seems like a very simple thing that people would record the parties, right? But very often the incorporation, where the parties are incorporated, is a very relevant fact, because as you can imagine, that determines, in our example, whether it is a domestic arbitration or an international arbitration, what rules will apply. For example, in a time limits in 29A as per our Act apply to domestic arbitration. So it is relevant where the parties are incorporated, and it's very important to record that correctly.
So the identity of the parties as well as counsel in international commercial arbitration, it's common practice for you to list the names of counsel and their details as well. A slight issue or complication arising from this would be if there's funding arrangements. So the DELOS rules does require parties' legal representatives to inform the tribunal if there's a funding arrangement and the persons whom they're taking instructions from. I think for good order as an arbitrator, I would record such information within the party's information as well.
Yes, particularly since the recent amendments to the IBA guidelines also now require disclosure about third-party funding. It's simply so that everyone has a sense of who actually has an interest in the outcome of this arbitration.
And the arbitral tribunal, if it's a sole arbitrator, it's quite straightforward. It's details such as the dates of appointment, when the person was appointed by the institution, the letter of appointment, etc. When it's a 3-member tribunal, then you have to state out details of the party-appointed arbitrators as well as the presiding arbitrator. The next slide, please.
So a lot of what Legion was just talking about finds itself in the procedural history. Very often, it's important that every award have a procedural history. While this seems pedantic in many ways, that you're just recording dates and events of things that actually happen, it's critical because it does lead to avoiding challenges subsequently. So for example, where the arbitration was recorded as consent of parties under the DELOS rules, subsequently in a challenge, and assuming this is a post facto consent of parties, subsequently in a setting aside, this should not be an issue. So therefore the procedural history plays a very important part in the arbitral award.
Yes, and just now we mentioned the default award when there's a non-participating party. Again, those kind of details will go into the procedural history. As the arbitrator, usually I would take pains to record the measures I've taken to ensure that the non-participating party has been adequately notified of the arbitration, to avoid them later at the enforcement stage rocking up in court and claiming that they did not have notice. The arbitration agreement and jurisdiction, these would be very peculiar to arbitration awards, of course. The power of the court is drawn from the state, whereas for arbitrators and arbitral tribunals, we don't have that luxury. So we have to be very careful about setting out the foundation of our authority and establishing the arbitral proceedings. You could have circumstances where, for example, the law of the seat is not clearly stated in the contract, or the law of the arbitration agreement. In those situations, if the parties can independently agree, for example, during the first case management conference, it's helpful to record that in the award as well.
And like we already discussed, administering institutions, critical to have it recorded in the arbitral award. Just to give you an example, there's an institution which rendered an award in a case of ours, and the rules allowed for a certain authority of the institution to make a determination as to challenges to an arbitrator. The opposite side did bring such a challenge, and fortunately for us, such authority was conflicted from passing any sort of view in our case, because there was a conflict situation. And so automatically somebody else within that institution had to take that decision, because someone in the institution has to decide. This of course became subject of ground for challenge in section 34 and is still pending, of course, but needless to say, the fact that the rules were clearly drafted and parties had agreed to those rules made it a lot easier for us to defend a setting aside request on that award.
So I think one other point to add on the arbitration agreement and jurisdiction, if the parties can agree, whether in a contract or otherwise, that's wonderful. If they can't, then do take note as an arbitrator, you do have to write down your reasons for concluding that the seat is a certain jurisdiction, etc.
I think while DIA of course is dealing with the parties' position and reasoning, we're not going to go too much into it, but the award should of course recognize what exactly the parties required, if there was a counterclaim, what the respondent also sought for in the proceedings.
The factual background, I think it's a way of the arbitrator demonstrating that they have clearly followed the proceedings. One of the easiest methods would be hopefully to be able to cut and paste the parties' submissions, but if they are not of the kind of quality or with the kind of conciseness that you're looking for, then some sort of perhaps additional work will need to be done by the arbitrator. So this leads us to the next slide, issues to be decided.
Legion, I don't know for you, but in domestic arbitrations in India, we will have an entire hearing just to determine issues between the parties, which can be fairly contentious. In my experience in international arbitrations, we don't run it like that, in the sense that you may not have a hearing where both sides argue what issues should be framed. It's a lot broader, but the importance of that, why don't you tell us?
Yes, I actually quite like the idea of having a hearing just to determine the issues, because it is that critical. In international commercial arbitration, it's more common for it to be submitted by the parties, and then the tribunal goes away and sometimes put together their own list of issues. Obviously, you would like the parties to agree, and sometimes they agree to a list of issues that might not really make sense, and that's when there needs to be intervention. But the issues to be decided is key, because it crystallizes the points which you think need to be answered for there to be a final and enforceable award. I think on this point, one thing, be careful not to exceed jurisdiction. So if the issues have been agreed, we can't just put in a new one just because in the course of proceedings we feel that it's correct. But if we do, or we feel strongly about it, then something to be ventilated with the parties. In relation to the DELOS rules, I'll also note that it does state that the issues to be determined should be set out in the notice of arbitration, defense, etc. In short, the statements to be submitted by the parties.
Yes, absolutely. Even for us, from a domestic perspective, one of the grounds for setting aside a domestic award is where either an issue that was decided as an issue has not been determined, or there has been overdetermination. So, very critical, of course.
I think we won't spend too much time. This is the meat of it, the analysis and reasoning, because we're going to hear a lot more from Dia, who I think has much better comments to share in relation to that section. I'll just touch briefly on the costs and interest here. It's meant to be usually in the substantive part of the award as well. And I will be touching, I think, on more details in that in the money section of our presentation. For the next slide, please, on the dispositive part.
The dispositive, of course, is what everyone reads first when you receive an award. You come to everything else later. Who's won, who's lost, what did we win on, what did we lose on, and why. Essentially, it is your conclusion section, and Dia and I will be also running a short exercise on this towards the end of the session.
And now, deviating from our structure, these are just, for the next slide, just some general considerations. The first is adverse inferences. It doesn't fit neatly into a structure, but I thought it was worth mentioning because as a tribunal, you might be asked to draw adverse inferences, which can be quite, I think, a tricky thing to do. I think the general rule of thumb would be very careful before you draw an adverse inference. For example, if a witness who has put in a witness statement does not appear at a hearing for cross-examination, does not necessarily mean that it's still safe to draw an adverse inference in the sense that everything the witness is going to be saying would be necessarily prejudicial to the party whom he's appearing as a witness for. The safer option might be actually then to decide how much weight you want to place on the person's witness statement.
For joint and several liability for costs, or even otherwise in terms of liability, a very clear set out sort of reasoning as to why the arbitrator has come to that conclusion, particularly falling back on the relevant law or rules that are being applied to come to this conclusion.
Yeah, so I think the joint and several liability for costs might be more predominant when, for example, you have multiple respondents. If it's cost of, let's say, $2 million, right, and it's not clear which respondent has to pay how much, it's much better to be clear in terms of the direction. If it's going to be a joint and several liability, then just state so. It's not going to be very difficult. For dissents, in a 3-member tribunal, which is also contemplated under the DELOS rules, there might be times when you might feel compelled to put in a dissent. My personal view is that it's helpful to put in dissent only if you think that there are issues with due process or extremely unbecoming conduct, which should be highlighted and then might potentially form grounds in relation to the enforceability of the award. But otherwise, unless there's an absolutely need to, you might want to think twice about whether to do that.
Just in addition to these general points, some basic requirements for us from an India perspective, a signed award. So in terms of our act, we need to have a signed award delivered, and we are seeing currently a challenge where the arbitrator made known to the parties that the award was ready and you must have it collected. The party that obviously lost never collected the award, so they claim to have never received the signed award. So the claim is that, well, the arbitrator ought to have sent it to me and not asked me to collect it. So these small things that there must be a signature on the award, they seem very minor, but they can have huge ramifications subsequently.
For unconscious bias, I think in relation to a 3-member tribunal, the sort of first concern might be whether party-appointed arbitrators might be more prone towards their own party. So I'll just leave that aside as just a potential risk. I would say that for sole arbitrators, there's also that risk in the sense of we're all human, and if we think that a party has behaved unbecomingly, does it steer us towards another conclusion against them? So I think the point is it's important to repeatedly stress test your own analysis, and I think Dia will be able to cover that as well in the reasoning of the award. A last point on AI, I'm not going to go too much into it. I think it's clear that no one should be feeding the documents into the AI and saying, please draft the award for me. There should not be an abdication of the tribunal's power and authority to make a decision. But if you're talking about summaries, etc., I think that's something which is still within the bounds of it. In short, no abdication of the power-making decision.
Absolutely, and like Hafiz said, ultimately it's ownership. So while you could use AI for maybe putting together, the procedural history part of it, I would say, ultimately you own your award, and
yes.
yeah.
Well, I think this brings us to the end of our section. Thank you very much.
Thank you.
Thank you.
In fact, an anecdote that I like to share, and Shruti, this is from what you just said. We are in fact briefing Ms. Kapoor in a matter where the tribunal consisted of three people, and one person did not just not sign the award, but sent an award much later than the majority award, once the majority award was delivered. So the minority, or rather the dissent, came in much later, and no signatures and no reasoning for those signatures being missing was actually put in the majority. So we are before the Delhi High Court. I'm so happy that we are actually discussing this topic, and we've briefed Ms. Kapoor on it, and hopefully, yes, fingers crossed, it should be in our favor, but please don't do these mistakes once you are writing those awards, and make sure that you have all those checkpoints in place. And this is a great position, a segue for me to please invite Ms. Kapoor on the dais here to really talk about the meat of the matter, the positions of the parties and the reasonings. Just before you start, ma'am, I'd just like to also say this is intended to be an interactive exercise, so I would really request you to please note down all your questions and answers, and we are going to deal with it towards the end of the session. So you will get a chance to also ask those imperative questions. Thank you. Your floors.
So, since Archil has said this is going to be interactive, I'm going to start with a question. First Nidhi said that, look, this award needs to be read by my promoters, and just keep it really simple. Just tell me what it is. What is the award? Don't get into anything. So we could possibly just have an award which has the ultimate decision of the tribunal, which is, what we call the dispositive section. Could we get away with that? If you think we could get away with that, hands up. No, right? We need reasons for the award. And why do we need reasons for the award? I think firstly, the Act says so, right? Our Arbitration Act, if you can just get to the next slide. The Arbitration Act, Section 31, says very specifically that the arbitral award shall state the reasons upon which it is based. And this is our act, but I'm sure every rule, I'm sure the DELOS rule has it as well, right? And I'm sure every jurisdiction has it, because essentially that's sort of, the meat of natural justice. There has to be a reason for what you decide. Now, one more question. Is it good enough for me to say the plaintiff's case was as follows, or in this case, the claimant's case was as follows? They have argued A, B, C, D, E, F, G. The defendants or the respondents have argued X, Y, Z, and in my view, the claimant is right, and therefore I award. Would that be a reasoned award? Hands up if you think so. Okay, anybody hands up on why that's not a reasoned award? The reasons, right? So when we say that there must be reasons set out in the award, how do we set out those reasons, and what are those reasons that we set out, right? When we're talking about a civil dispute, what would you would look at the evidence. You would say, look, these are the submissions that the claimant has made. The claimant has argued A, B, C, D on the basis of such and such clause in the contract, on the basis of such and such law. This is the law they've relied on. These are the clauses in the contract they've relied on. These are the facts they have argued. This is how they have proved their facts. This is the standard of proof. This is the burden of proof they've discharged. Then you would say this is what the defendant has argued. These are the facts as presented by the defendant. This is the evidence presented by the defendant. How has the defendant discharged its burden or standard of proof, right? And then ultimately applying the law, applying the clauses of the contract. This is how those facts that stand proved. I have applied X, Y, Z in the contract, or I've applied the law. This is the settled law. I would cite all those cases, although Nidhi does not want me to cite those cases, and finally come to a conclusion that this is the reason why I have decided what I have decided. Those are the reasons in the award, right? Now, in every award, you will have many issues. You're not going to have one, right? So if you see the structure that was set out a little earlier, where in the award, I mean, I would say just, being A as an arbitrator or B as a counsel sometimes challenging an award, it is much easier to have all the submissions and the positions of the parties set out issue-wise. So the points for determination or the issues as framed, what you ought to do when you're writing an award. So, we follow the structure of the award that these are the parties, this is the procedural history. Then you come to, these were the issues as were framed. These are the points for determination. Take each point, and on each point, set out what was the point that was determined, what is the claimant's position on that point, what is the defendant's position on that point, and then what is the evidence led, what is the law, and what is the conclusion, right? That is the way you ought to structure an award. Now we'll just flip through, why we need this, right? One is, what is the audience for your award? The audience for your award is obviously the party, which really just wants the dispositive section of the award. But the audience for your award is also the judiciary. Your award needs to be upheld by the court. And in order for your award to be upheld by the court, it has to stand the test of the Arbitration Act. It has to stand the test of the formal requirements of the arbitration award, which are what's set out in Section 31. And it also needs to stand the test of Section 34. How do you ensure that your award stands the test of a Section 34? And as arbitrators, that is the key, right? Of course, the award must be nice to read. The award, must be clear. The language must be nice. It must be, easy on the eyes. But the most important thing for our awards is to stand the test of Section 34. And what makes it stand the test of Section 34 is the reasons. Your reasons must be clear. Your reasons must be concise, and they must not be contradictory. So be very careful when you are drafting your award to ensure that you have set out the reasons very lucidly, very clearly. And also, please make sure that the reasons in one part of the award do not contradict the reasons in the other part of the award. So let's just flip the next slide. So this was just Section 34. Where does this come from? Where does the fact that one is, of course, you have Section 31, which says set out the reasons. You then have Section 34, which says that if it is contrary to the fundamental policy of India, or just the next slide, please, or if there's patent illegality, right? These are sort of the two tests that we have to meet. And let's flip the slides. You'll see how the courts have, we can flip, Section 48 will also have a similar test, but a little narrower. So you may get away with unreasoned award sometimes in a foreign award, but you won't get away with an unreasoned award in a domestic award. Unless, of course, there is, as we all know in Section 31, you can dispense with the requirement. Parties can say, look, we don't want reasons in the award, but absent that, you must have reasons in the award. Can we just flip the slide? This is arbitral, carry on, which is what ours is based on, and therefore, anywhere in the world, if you have to enforce your award, you should have the reasons. So all the judgments, starting from associate builders, which we all know is really the one judgment we will all go to for any Section 34, is that you have to provide reasons for the award. And it says it would be regarded as a patent illegality. So not only are you violating your Section 31, but it is a patent illegality if the reasons for the award are not stated. Can we flip? And these are all just, we can just flip these quickly, but you will see judgment after judgment after judgment, which says that if there are not valid reasons given in the award, it will be set aside for patent illegality. And in fact, just if we can go back to the DMRC slide, DMRC, this all the way up in the curative, took the position about evidence not having been considered, right? So when I said when we're looking at reasons in the award, the reasons in the award can't simply be, I thought so, in my view, right? That's not the reason. I have to consider every piece of evidence. So the helpful way to think about it in a slightly structured way when you're writing your awards is claimant leads their evidence, defendants lead their evidence, consider every piece of evidence that has been led by the claimant. Discuss all of it in your award. Because if you do not discuss that you have considered this evidence, you could leave yourself open to a DMRC situation where it will say, well, you have not considered a vital piece of evidence and therefore your award is liable to be set aside. So really, and when we say evidence, there will be testamentary evidence, there will be documentary evidence. Look at how on each issue, what evidence has been led on that issue, what arguments have been made on that evidence, how that evidence proves or does not prove the fact that they're trying to show, and set it out very clearly in your award. So, I mean, that's sort of the broad outline of why it is really important to state reasons in the award. The second aspect which I was touching on was positions of the parties, right? Do I have to set out what is the position of the party? And this has two aspects to it. One is, again, if you see the Arbitration Act, and it says that if the award deals with a dispute not contemplated by or not falling within the terms of submission, or it contains decisions on matters beyond the scope of submission to arbitration, it is liable to be set aside. So unlike a court where two parties may be making any arguments they want to, and the judge feels, well, actually the reason to decide this case is something completely different, which nobody has argued before me, and I think that's actually the correct argument. A judge has it within them to write a judgment based on what it thinks is right and what, according to it, is finding the truth, so to speak. An arbitrator does not have that latitude. Arbitrators have to confine themselves within the four corners of the submissions that have been made by the parties. And therefore, it's important in your award to record very clearly what is the position of the parties. What are the submissions that have been made by the claimant? What are the submissions that have been made by the defendant? And therefore, this is the position of the parties, and based on these two conflicting positions, this is my decision on the basis of the evidence, on the basis of the law, on the basis of the contract. But it has to be based on the arguments and the submissions that have been made by the parties. It cannot fall outside the four corners of it, so record the position in your award. I think that's about all I'm going to touch on. I think that's about all I have time to touch on. So we'll come to the more, so there are two important parts of the award, and not just because I'm speaking on both of them, but one is the reason, the other is the dispositive part, so we'll come to that later. Thanks.
Thank you so much. What this reminds me of is when she said that two issues should really not contradict each other. It's a little thing that we did an arbitration where the arbitrator decided all the issues. There were about 5 issues. One of them had a computational error. So what he did was, he took issue 1, said A plus B equals C, went to issue 4 and said, because A plus B equals C, I am deciding this in this manner or whatever. The other side filed a section 33 application, which is, as you all know, for a correction of the award. That award was corrected only restricting to issue 1. So what he did was he forgot that there was an issue 4 that relied completely on issue 1. So A plus B was now not equal to C, but issue 4 said A plus B equals C, and that is why this is my conclusion. And really how it plays out, once these awards are actually issued is very, very interesting, and it all seems really tedious right now, but when it really plays out, it's super, super interesting. With this, I'd really like to call upon stage Lee Jun. Lee Jun, if you could join us. Oh, wait, no, this is Nidhi and Shruti. I'm so sorry. So drafting styles and audiences. Of course, we have 100 people in the room today. As lawyers, all of you have 100 ways of drafting your pleadings. What styles should you adopt as arbitrators? Is there a set format? Is there a distinction between domestic award or an international award? How do I really approach it? I'd love for you guys to please come in and weigh in on this. Lijun and Shruti, everyone. Nidhi and Shruti. Oh, sorry. Sorry. I have this wrong.
Yeah, that's fine. Actually, I don't think there should be a difference in the drafting styles we say for domestic and international. And more, as we see, I mean, just in the last 5 years, for example, the way we conduct our domestic arbitrations is becoming pretty much, coming up to the standard of an international arbitration. There's a few peculiarities, but particularly when it comes to a award, why would you expect a difference of standard? You just expect the best award, whether it is domestic, international, seated in India, seated outside. But Nidhi, when you receive an award as, a party, are you very impressed with big English words in it?
As far as English and not Latin, I'm still better off.
Yeah.
So if that was my choice, yes. But again, not the fanciest words which are not easily understood by a layman.
But easily understood, right?
Yes, absolutely.
So, I mean, like Dia said, it was so important to have your reasoning right as the arbitrator. But what good is having that reasoning sorted in your mind if it's not something that you've been able to communicate in the award? And so I think the first rule of drafting the award really is a simple award. Simpler the better. Simple, of course, does not mean Control C, Control P. That's too simple, and that's going to land you in a whole different kind of soup. But simple enough for the readers. And while we do keep saying that the reader is the party, honestly, I'm writing an award and my reader is the party. It's always the losing party first. Then, because they're the ones who are going to challenge the award. The winning party second, and then the thought of the High Court, of course, is always all pervasive every time you're writing an award. But do you feel there should be a difference in maybe more technical awards? Like, for example, if we do a construction arbitration and you have an award, or you've done so much oil and gas, those can be so much more technical, right? Do you see a difference in a pure contract dispute and a more technical dispute in the style of the award?
Well, I think the difference is, and I think this is also one of the beauties of arbitration, is that I'm not going to a judge who may or may not have expertise in that subject. As an arbitrator, in an arbitration, as I can choose an arbitrator who comes from that field. More often than not, you appoint an arbitrator who could be an expert in that subject. So a lot of times what they are narrating in their awards is also coming from experience. It's also as good as setting the ground for future events, as is prevalent to the practice in that particular sector at that point in time. Having said that, yes, they get a little technical. They can be extremely, extremely dry for a lawyer to understand, because they may not have the experience from the technical perspective. And being in-house or being external counsel, what the advantage we have is that we can sit down with the technical team and understand that part. But if it is technical and it is pertaining to that, no problem. Ultimately, your award is still again on the legal point of it. That, if it stays simple, it helps all parties to take care of and maintain that work. I think when it comes to any technical industry, getting into the technicality, because a lot of times, apart from the basic contractual disputes, if there is something that needs to be thrown light upon, it is these arbitrators / experts who can add value to it. And I think that's one thing I think I kind of appreciate being clarified in the award as well.
But you're right, who your tribunal is has so much to do with what your award looks like. If you have a 3-member tribunal which is presided by a technical member, that award reads very, very differently than a 3-member tribunal where one may be a technical member but the presiding is still an advocate, or a retired judge, or so those awards read very differently, simply because the technical person who's writing an award tends to assume that everyone else understands what they're talking about,
right,
which is very often not the case, but what can we do about that?
Same goes for lawyer and technical. I've actually had arbitrations where one of my arbitrator was a technical expert and the other two were lawyers, one being a retired judge, as coincidence would have it. And it wasn't always easy to keep either of them interested if we were talking about subjects, while arguments which were not pertaining to technical / legal, depending on who was listening to it. So I think, again, ensuring that you're dealing and referring this, keeping it simple and keeping it crisp, as Dia also said it, ambiguity and keeping, we have these awards which read paragraph 2 with paragraph 4 with paragraph 8, and by the time you're like, okay, what am I reading? And they're like, you give it to a promoter because they want to read it, and believe you me, they have a lot more knowledge and insight on law than a lot of practicing lawyers would have. Trust me, they are very well versed with their law. So they would just say that, what does this mean? Again, another point, I'm sorry I'm taking an extra minute here, is that we're forgetting the flavor or the reason why arbitration practices came into existence. It was to ease the work of the courts. Here, half the times if you're going to the court because of interpretation issues, I mean, how are you easing the court's work? So it's these basic things you're keeping in mind. And I was just discussing with Lijun before our session started that, you know, more often than not, if I was an enriched party, you know, with resources, I will find the best lawyer. And if there were two parties to the matter, right, one being enriched with resources, one with limited resources, I will find every loophole in the award to have it dragged for years and years if that award is not in my favor. Now, if you flip that, the party with limited resources, while may not have the clarification, will say, let's just let go of this thing because I don't have the time and money to keep spending on this. So it ultimately boils down to money. But in the entire process, who's losing out is again us, not just as lawyers, but as humans who might have to, you know, go through this cycle again with other set of parties, etc. So I think when you set the ground rule clear the first time, you do a lot of good for everybody who's getting impacted with that judgment or the award.
Yeah, that makes a lot of sense. So broadly, I think what we're saying is everyone can have their own drafting styles as an arbitrator. Keep it simple is the first ground rule. Keep it short, as crisp as possible. Sometimes arbitrators feel the need to over-reason. That can also lead to potential issues where then in that over-reasoning you end up contradicting yourself. Of course, you're writing an award with the mindset of enforcement, and you must remember that the enforcement is not just in your jurisdiction where the seat is, but it could potentially be several other jurisdictions, so that's something to be kept in mind. Small things like, for example, humor or sarcasm when you're drafting an award. Often the way you're thinking it's like text messaging. Sometimes the way you think it and the way it's delivered can be a world of difference. So it's similar to that, you know, in an award. If you think you're trying to be funny, it may not translate very well, you know, to a third person actually reading it. So yes, broadly, I mean, just keep it simple, you know, cover the most you know, relevant aspects right from the structure that we've seen through the day. And yeah, that's about it.
On a lighter note, I have a question for Shruti. Have you ever seen a party raising objection to any of the humor cited or mentioned by the judges or the arbitrator story, and then taking objections or
I have raised an objection to an award where I don't think, of course, the arbitrator meant it in that way, but I said, just look, he was biased from the start, look at it.
Exactly. So, there you go. So I think that's exactly what I was trying to nail down to, that you just, you know, you give out a flavor of bias when you behave in any way, trying to show that one of them is not better than the other one.
Thanks.
Thank you.
Thank you both. Thank you. Thank you. I'll keep this short because I know we are running short on time. But I would like to invite Lijun now for really the reason why the parties are here, which is the money sections of the award and what really you have to focus on when you're writing that particular section. More importantly, it's really relevant in the Indian context because as you would notice, a lot of the awards that we come across would not have very detailed money sections. So Lijun, if you could please help us out with this. Thanks.
Thank you. So as Sandra mentioned, we start the arbitration for the money, right? Next slide, please. So I'll just talk about the first remedy, natural remedy first, damages. I think that all of us as experienced practitioners would have a lot of, would be able to draft that part in our pleadings or submissions already. So in that sense, it's not all that different, the precision. So for example, saying, I find that a respondent has breached the contract and calculate the damages as euros $1 million. It's not going to be sufficiently clear in the context of an arbitration award. You literally need to direct the parties. In this case, it's much better to say respondent is to pay the claimant immediately the sum of euros $1 million, 1 million euros. Now, somewhat associated with that, some of the considerations when it comes to drafting the damages part of the award currencies, that's an obvious one. If there's going to be multiple currencies, do consider whether this is going to be an issue in the law of the seat or in other jurisdictions where the award might be enforced. Names of the parties sounds like a clear and obvious one, but there have been cases where it's been difficult to enforce the damages order, not least because the name of the party was wrong. And this could occur in situations where you're talking about a large group of companies with very similar sounding names. So it's simply an issue of the tribunal being extremely meticulous and careful in terms of identifying the party. Another situation where it could arise is, for example, if it's joint ventures, in what capacity a party is participating in the arbitration, and then making the necessary association with the damages order. I've put bank charges and taxes on this slide because recently I did have a party asked to clarify if bank charges and taxes should be deducted from the amount to be paid as damages. I think to most of us it's quite clear that if it's 1 million euros, it should be 1 million euros clear of bank charges and taxes, etc. But I thought I'd just raise this point. The last bit is around punitive damages, which I think in the jurisdictions that we're familiar with is more unlikely to be awarded. But in some jurisdictions, there might be the temptation to award the punitive damages, maybe because of deplorable conduct by one of the parties. Again, just to bear in mind whether it's something which would be permissible under the law of the seat or any other jurisdiction that might apply. Next slide, I'll move on to costs. So the starting point is cost is entirely within the discretion of the tribunal. The DELOS rules makes that very clear as well. It's up to the tribunal to decide who should pay the cost. We would usually follow the cost follows the event rule. I think for the DELOS rules, it does clearly state the considerations in 12.4, I believe, that the tribunal should take into consideration when deciding the award of costs, and this would include, for example, offers to settle. For costs, I find it helpful personally to think of it as two broad categories. The first, the cost of the arbitration, so basically the cost of the tribunal and the cost of the administrative institution, your hearing fees, your transcription fees, all of that will be under the cost of the arbitration. And it's more common for that to be 100% awarded in favor of the successful party, meaning the losing party should bear the full cost of it. But again, if you're the tribunal, if you're the arbitrator, it's within your discretion to decide whether it should be 100, 90, or 80%. Now, party costs would be those legal fees and expenses of their lawyers, or their experts, or their witnesses, and the internal cost of the party. In some international arbitrations, it is quite common for the parties themselves to claim their internal costs. So for example, whichever director or somebody in the business team who has been devoting 200 hours to it, and they'll charge the other side accordingly as part of their costs. Again, costs follow, based on the principle of costs follow the event. Usually the successful party should regain their costs, but the question of percentage is again up to the tribunal. In international arbitration, it's common for the tribunal to look at the cost schedules for both parties to decide, for example, so if one party's legal costs ended up being 200,000 versus the other side who has racked up $1 million in fees, that could mean that a reasonable amount of cost might be somewhere in between. Again, very much within your discretion as the tribunal. Now, still staying on costs, one point to consider is the time for addressing costs. I think the golden rule is that for a tribunal, you can't issue an award on costs until you have heard the parties on it. So it's very important to hear what the parties have to submit on the issue of costs. The question is, do you do it before you have decided on the substantive issues, i.e. who is the losing or winning party, or do it after? Doing it before would mean that the tribunal would order the parties to put in their closing submissions perhaps a cost schedule and brief submissions as to what the cost decision should be. The other way of doing it would be after the final award, or rather, the award on the main issues have been published and you know who the losing or winning party is, and the parties will then submit how much it's, the cost should be awarded in favor of each of them. I think that would mean that the winning party might be incentivized to put in costs that you might expect to be higher than if it was before the decision. But again, it's up to the tribunal to decide. Offers to settle, I think most of us in this room will be familiar with the concept. I think the short point is that this is also something to be considered in arbitration. The DELOS rules again also includes offers to settle as one of the considerations for the tribunal in terms of deciding how much cost to award. Now on third-party funding, as Shruti has earlier mentioned, under some rules, it's important to notify the tribunal if there has been third-party funders. The question then is, can the tribunal or should the tribunal order the losing party to bear the cost of the premium paid to the funder? There's some case law on this, and definite situations where the successful party could claim the premium paid to the funder, but that's usually where there's egregious conduct. I think this is one area that we need to be very careful about, and I think it's more commonly found that perhaps the premium paid to funder will not be one that has to be borne by the losing party. Moving on to contingency fees. Very briefly, for example, a lawyer might promise the party, you will have to pay, let's say, 200,000 for my fees, and if I am successful, it's going to be another 50% to it. The question is, the 50%, is this something which they can claim from the other side? Some jurisdictions, such as Singapore, say that you cannot make the losing party pay the uplift of the 50%. Some jurisdictions do allow them, such as Hong Kong, leaving it to the discretion of the tribunal. So for a tribunal who's being asked to decide whether the uplift fees should be borne by the losing party, you should look out for these issues. Moving on to interest. Interest can be awarded on damages or on costs. The interest rate to be applied would usually, even in the situations of international commercial arbitration, would usually follow the local statutory interest rate in the law of the seat. Time when interest begins to run, the default rule or the common rule would be from the time of the award. But if the damage that has been pleaded relates to events that happened prior to the award, and there's a good reason that interest should start to run from the particular event of breach or whatever event it is, then the interest rate should run at an earlier time. And of course, interest would usually apply up until the date of payment. Here you can see I've put in the box the reasoning portion in relation to interest. So sets up very briefly what the claimant's submissions are as in relation to interest rates, the respondent's submissions, and the tribunal's reasoning as to why it should be following the law of the seat. Next slide, please. So my last slide in relation to interest. I've covered very broadly general interest, the appropriate rate up until the date of full payment, and perhaps again, sometimes an adjustment required for multiple currencies. The golden rule is interest is meant to compensate the claimant, not penalize the respondent, and that's why the local statutory interest rate would usually be a good point of reference. Pre-award interest rate, I've covered that earlier, but again, I think the short point is that it's less frequently applied. Compound interest, in my mind, makes sense only if factually the unpaid party did suffer the loss in relation to the compound interest, and if so, you then do it at monthly or 3 monthly arrests. And the last point, of course, if interest is forbidden under the laws of the seat or in any other jurisdictions in which the award might be enforced, then it's something which you obviously would not be able to include in the award. Thank you.
Thank you so much, Lijun. Just a short point here, a lot of the domestic arbitrations, and in fact arbitrations seated in India, sometimes do not accept, or rather they don't have the practice of accepting cost submissions or submissions on cost. So when you are sitting as an arbitrator in India, like Lijun said, you may benefit from the cost submissions submitted by parties. So it's you can keep that in your mind when you are drafting the first procedural order and actually have that as a stage at the beginning of the arbitration, and it really help in the cost section of the award. May I now invite Shruti and Diya, please, to take us to the last segment of this training, which is very interesting. It's an exercise about the dispositive sections, and I leave it to you both.
Now we'll check if you really were listening to what was being said. This is just a fun exercise. And it's very subjective. There's no right and wrong, really. So
No, there is right and wrong, guys.
I was trying to use okay, fine, there's right and wrong. So what we've done is we've put together, a few examples of the dispositive section. We're going to bring them up for your consideration, and then we'd like to hear from you any issues that you can find in this.
And when we say the dispositive section, that's sort of the last part of the award, which says X has been awarded, Y has been awarded. And to just start off, before you look at it, the idea is that it should be very clear and concise. There should be no ambiguity whatsoever in what is the direction that the tribunal is giving. So what our exercise has done is it's created perhaps some with ambiguities and some without, and we'd like you to point out where you feel it should be better drafted.
So this is a dispute between Alpha, who is the claimant, Alpha Engineering Limited, and Beta Trading Private Limited, which is the respondent under a supply agreement. Alpha Engineering Limited seeks a payment of 500,000 USD for goods that it delivered to Beta. And the respondent, which is Beta Traders, argued that the goods were defective and it seeks counterclaims, essentially damages, for $200,000. The dispositive section is on the screen before you. The tribunal thinks
So the way it's been drafted, and we'd like you to tell us how we perhaps could redraft it, if at all, or if you think it's fine. The tribunal thinks Alpha should win. So Beta is to pay Alpha 500,000, which should be done quickly. Beta's claim for compensation about the bad quality of the goods is rejected, since we don't think they proved it very well. Costs will be decided later, maybe depending on what happens if Beta pays or not. So anybody, hands up.
My name is Sushil Chandra. So if you look at the dispositive part, probably an intern in a good law firm also would probably draft something better than this. So the tribunal thinks, so the word thinks is again subjective. There's no reasons for it. So that's one thing I can see. It should be done quickly. Quickly is also not very clear. It's a sort of wait a date or a time period before which it should be done to a definition. What is quickly is a matter of interpretation. Where is that? Yeah, I'm correct. We have 500,000 what? Euros, dollars, whatever. That the currency is not mentioned. Since it's rejected, since we don't think, again the word think, they proved it very well. That also could have been worded much better. The manner in which it was proved, and costs will be decided later. Maybe the word maybe again. Maybe depending on what happened with Beta pays or not. Like I said, very widely drafted.
Okay, will somebody else just take a crack at drafting that first part then?
Go ahead.
It's not a definitive order itself. It says tribunal thinks it should be done.
Yeah.
It's not a definitive.
Absolutely.
It is not a finding. It should be a finding.
A clear finding, yes.
It will not be binding actually. So there is no finding, no binding.
Yeah.
And
Yes.
there is no
For later, yeah.
for payment also there is no timeline given. So for better enforceability there should be timelines.
Absolutely.
Yes.
Even it's a responsibility, so all it needs to be say the tribunal orders, then Beta will pay Alpha $500,000 on so and so date, and the claims of Alpha, claims of Beta are dismissed. These are the only two things that are.
Absolutely.
And as far as costs, if there is an order, it will say costs are awarded. If costs are deferred, then it will say award, say offset the costs.
And of course, not deciding the cost. I mean, that's such an odd thing for a dispositive to say. It depends, and we'll see. Maybe subsequent. Because the moment the final award has come, the tribunal is functus officio. So there's no question of it deciding anything, later like that.
Just one quick point. The very first sentence there is a problem. It's a conclusion, and there are no. How do you come to that conclusion? There is no discussion on that. So So this is basic jurisprudence that anything, a conclusion cannot come first and cannot followed by instance. And there are no reasons.
So this is the dispositive part of the award. You know, like we discussed, the award is broken up into various parts. The conclusions, the reasoning will come in a different part of the award. This is the sort of, final. It's almost like, in a pleading, what you'll call your prayer clause, right? So these are the prayers that have been granted, so it's called the dispositive part of the award.
But a fair point still to, basically it could at least say because that...
for the reasons stated above.
For the reasons stated.
Yeah, since we have already found the breaches by beta against alpha, something to say that.
The ambiguity part is.
Yes.
One more thing, it should be serial number, like different heads dealing with different 1, 2, 3 or A, B, C, D for better understanding for 34 codes.
Yeah.
Or 37 codes.
Yeah, that's a great comment.
Good point.
Okay, yes. Silent about the interest, yes.
Also a good point.
Maybe we'll now move to the next example.
So I'll just read this out. It says Gamma Solutions Private Limited terminated Delta. So Gamma is the employer and Gamma terminated Delta, the employee, who is the claimant, a senior project manager alleging gross misconduct for unauthorized data transfer. The employee seeks 1, a declaration that the termination was wrongful, 2, payment in lieu of 6 months notice per contract, 3, unpaid bonus for the prior fiscal year, and 4, compensation for reputational harm. The employer counterclaims for liquidated damages under a non-solicit clause, alleging the employee solicited a key client post-termination. And this is our dispositive. Since we think the firing wasn't handled properly, Gamma must undo its breach and what it did and give Delta all that is due to him/her, including 6 months' money and the bonus for the previous fiscal year, which is 1.2 crores approximately. Of course, interest will have to be paid by Gamma on these sums. 2, as for Gamma's complaint about the breach of the non-solicit clause, that's not convincing, so everyone should pay their own legal costs. Volunteers.
Once again, the formation of the dispositive part is not clear because it's a long sentence. Usually, whatever you just stated, that should be clear and short sentence. And again, the currency is not given. Of course, interest will be there is no finding or there is no basis clear. So it's a vague.
Anyone else?
Please go ahead.
I'll just focus on the second part of the dispositive part.
Yes.
And presuming that there are more than one party on the respondent side, where it says that everyone should pay their own legal costs. So that is something which is
Odd.
not good.
Yeah.
Also, the amount that is there is given across, the interest needs to be calculated on the definitive amount. So you have to be very definitive about it. That's what you know.
So the second part, which is the breach of non-substitution clause and legal costs, I think they are unrelated. Both parts of that sentence are unrelated to each other because one is the first part is arbitration, which she has not addressed, and second part is the legal costs, which both parties may be paid. These two have to be separately addressed by the arbitrator, not like this, because they are not connected to each other at all.
Absolutely.
Yes.
In fact, the rate of interest is not mentioned in the first part. So, rate of interest has to be clear, whether it's simple interest and what's the rate of interest, whether it will be compound interest, from which date it will start, and which date it will end. Secondly, the approximate word used along with the figure 1.2 crores, that is also a vague amount. Once you have all the details and how much salary is required to be paid, the amount, when it's a final award, amount has to be certain that how much amount needs to be paid by either of the parties. So, first part of this dispositive part is also quite vague.
Correct.
I think there is no prayer for interest also. Claim is not there for interest, and I am reading.
And can interest be awarded if there's no claim? I mean, that's a separate matter.
Explained by the previous speaker, the tribunal should restrict itself to what is clear, not go beyond it.
Yes.
I mean, apart from the structuring, etc., I think there's also a contradiction that it says Nama must undo its breach
Yes.
and what it did. Now, one of the first things that they do is the termination, and then it goes on to say, including 6 months money, which is in lieu of the 6 months notice for contract. It's not very clear if they want the person reinstated.
That's right.
If there is a reinstatement from what date, and if there's a reinstatement, would you still get the 6 months money?
So is it a specific performance direction or is it a compensation direction?
Exactly.
There's a contradiction
So
there
there's
definitely.
that. Ideally, the best way to deal with something like this, where you have 4 claims, 1 counter claim, and then of course false interest, is to just break them down and one by one just knock them off, saying yes, no, yes, no.
Exactly.
In straight sentences.
And isn't it odd that they find very clearly breach and they find for one party but legal costs everyone must bear their own? Why should everyone bear their own legal costs?
I mean, we see that in our Delhi High Court cases on everyday
Hence,
basis.
why should we bear our own legal costs?
Parties to bear their own costs.
Conclusion for our speaker, I can say that night of uncertainty is killing the certainty of the relief in this positive part.
I believe the use of words that we, when we draft the operative portion of your word is very important. So here we see in the first part itself, the use of word think, Dhamma must undo its breach, then the use of word of course, interest will have to be paid. The use of these words is not correct.
Absolutely.
The operative portion should be very carefully done.
Absolutely.
And also just on that same sentence, right, all that is due to him or her, including 6 months and bonus, which is approximately 1.2. So what else is therefore being awarded as a consequence of this? Yeah.
We move on to our last example.
Yeah. So Vega Infrastructure Limited, the claimant, and Atlas Ports, the respondent, entered into a long-term hull construction contract with liquidated damages clause for delay and a cap on liability excluding loss of profit, except for certain milestones. Disputes arose between unpaid milestone invoices totaling so-and-so, Atlas's deduction of liquidated damages for 45 days of delay, Vega's claim for lost profits on a cancelled expansion phase allegedly triggered by Atlas's breach. The tribunal has jurisdiction under ICC rules, seat in Mumbai, Indian governing law. Both parties requested declarations on liability allocation and interpretation on the LD clause and liability cap.
So this is how we've drafted the dispositive. 1. Given everything discussed above and the commercial realities, Atlas should clear the pending invoices while keeping its rights under the contract intact, but neither side should treat this as a ruling on liability because the parties may still negotiate later as they see fit, and this award records that understanding. 2. On the LD and cap issues, we think the contract should be read in a business-like way, so liquidated damages can be adjusted if more facts come in. Also, both parties' broader claims are reserved so that any court or a future tribunal may sort them out as appropriate without being constrained by this decision. Anybody?
Ask for a declaration, they are not making it.
There is no finality to the specific part of all. It's all open-ended and it's all subject to whatever we have in the future. And that's not the intent of part of the job.
Yep.
Absolutely.
Potentially. It seems like parties have come to some sort of an arrangement that is also recorded here.
Can I say, this is the last example, right?
Yes.
Can I say something about these three? There's an interesting observation when Mr. Indra is sitting next to me. As badly as these dispositive parts might have been written, they are by themselves not reasons to set aside the award. It can call for clarifications, and many of these can be clarified. So you might not be able to set them aside just on these grounds.
I mean, the idea is really at this point we're looking at how we should draft an award as arbitrators.
I got the point. Like this, I mean, this step for
But you're right. I mean, this would be something you could perhaps go back to the arbitrator to clarify. But at the same time, it could also, lead to a situation of ambiguity in the award.
Unless you're a losing party in any of these awards, of course, then you won't ask for the clarification and you'll go straight to court.
Thank you so much. Thank you. I think this was lovely. And in fact, they did have 2-3 others prepared, but we are mindful of the time. Thank you so very much, our speakers. I now open the floor for brief questions. We have time for 2, maximum 3. Yes, the gentleman right here was very, very quick, so we'll take a question from you, please.